Hello, this is Subodh sir. So in the last many lectures, we have discussed many questions from Criminal Procedure Code which are very important from judicial examination point of view. Now today also, again we will take up few questions, and if a need arises, we will take up few more lectures in the days to come, and we will try to see all those questions which are very important as far as interview of judicial exam is concerned. Now to begin with, today I will take up the first question: who can file bail application for anticipatory bail and where it can be filed? Now if you study relevant section of CRPC, namely 438, you have elaborate provisions for anticipatory bail. Now section 488 says that anticipatory bail can be filed either in session court or in the high court. Now keep two things in mind. Question number one, you can either file in session court or in high court. So if you file in session court and your anticipatory bail is rejected, you have the option to go to the high court. But if you file in high court and your anticipatory bail is rejected, a question arises that once anticipatory bail is rejected in the high court, because you also have the option to file it in the session court, so whether you can come back from high court to session court and file anticipatory bail once again. Answer is no. You can file in the session court initially, and if it is rejected, you can go to high court. But if you file in the high court directly, and if it is rejected, you cannot come back to session court. So this is a provision with regards to anticipatory bail. Anticipatory bail can be filed only in the case of non-bailable offence. You cannot file anticipatory bail in the case of bailable offence. That is not allowed. If you want to have bail in bailable offence, under section 436 of Criminal Procedure Code, you can apply for bail, and because bailable offence is offence which is specified in the first schedule, and this bailable offence, in bailable offence you can demand bail as a matter of right. So as far as anticipatory bail is concerned, you can file under section 438. You can go either to session court or to high court. But keep in mind, if you go to session court first, after that you can go in appeal to high court if your anticipatory bail is rejected in the session court. But if you go to high court directly and if it is rejected, you cannot come back to a session court. There is a clear-cut judgment of Supreme Court on this issue. So this is the first question. Now let's take up next question. Now if an accused of a murder case is running in order to evade his arrest, can police officer fire on him to effect his arrest? If yes, whether police officer is entitled to cause death of the accused? So this question is like this: if a person has committed a murder and he is evading arrest, he is running away from the system, he is not surrendering in the court of law. So whether police officer has got right to cause death of a person who is accused of an offence of murder. Now if you read section 46 of CRPC, it clearly says that if a person has committed an offence for which punishment is death penalty and life imprisonment, then only police officer can go ahead and kill that person. If he has not committed an offence for which punishment is death penalty or life imprisonment, police officer cannot kill that person. So in this question, whether a person who has committed a murder, whether when the police is asking to surrender, if that person is not surrendering, whether police, in order to arrest that person, whether he can kill that person or not, answer is yes. So the right of police officer to kill an accused person, it is available only in those cases where that person has committed an offence for which punishment is either death penalty or life imprisonment. If he has committed an offence for which punishment is less than life imprisonment or death penalty, police officer को उस आदमी को मारने का इजाजत नहीं है, पुलिस को पावर नहीं है. So this point must be clear. Police officer can kill a person provided he has committed an offence for which punishment is either death penalty or life imprisonment. So this is so simple. You must keep this in your mind. Now, next question is, what is the difference between substantive law and procedural law? Now, substantive law is a law which defines rights, duties and liabilities of a person. For example, Indian Penal Code is a substantive law. And when you talk of procedural law is a law which tells you how to implement substantive law. So, Indian Penal Code is an apt example of substantive law. Criminal Procedure Code is an apt example of procedural law. CPC Civil Procedure Code is an apt example of procedural law. So the basic difference between substantive law and procedural law is that substantive law is a law which defines rights, duties and liabilities of a person, and procedural law is a law which tells you how to implement substantive law. Indian Penal Code is an apt example of substantive law, and this Criminal Procedure Code is an apt example of procedural law. Now, by what mode a person can be compelled to appear in the court of law? So if you study right from section 61 onwards of Criminal Procedure Code, you have the 4 processes to compel appearance of a person in the court of law. The first process is summon. If he is not coming on the basis of summon, then warrant can be issued. Even after that, he is not coming, he is not being arrested, then proclamation can be issued. Even if the proclamation is not serving the purpose, then what is known as, there will be order for attachment of property. So these are the 4 processes to compel appearance of a person, namely summon, warrant, proclamation, and the last process is attachment of property. So ये 4 तरीका है किसी आदमी को कोर्ट में appear करवाने के लिए, and you have the relevant provisions right from section 61 onwards in Criminal Procedure Code. Next question, which is very important: whether a major child is entitled to get maintenance. Yes, a major child, once a person is a major, he is not entitled for any kind of maintenance from the parents. But if the major child is suffering from some kind of mental or physical abnormality, in that case, he can demand maintenance from the parents, and parents are obliged to maintain such kind of children who are mentally and physically, abnormal and things like that. Now, until what time the warrant issued by a court remains in force? For this, read section 70 of Criminal Procedure Code. It says that warrant can be issued by the court, and that warrant remains in force till the warrant is cancelled by the court which has issued it. Sometimes you get this question in preliminary exam also, and sometimes this is asked in interview also. Which court can cancel the warrant? The simple answer is the court which has issued the warrant, only that court can cancel the warrant. And if you read section 70 subsection 2, is very clearly mentioned, the court which has issued the warrant, only that court can cancel that warrant. Now, until that time, that warrant will remain in force. Next question: when did Criminal Procedure Code came into force? Criminal Procedure Code came into force on 1st April 1974. Now, next question: what do you mean by inquiry as per Criminal Procedure Code? So you have 3 things: investigation, inquiry and trial. So inquiry is always by the court or magistrate to find out truth of the matter. Next question, very simple question, but sometimes we tend to forget answer for this question. What do you mean by judicial proceeding? So judicial proceeding is a proceeding where evidence can be taken on oath. So if you get a question, what do you mean by judicial proceeding? Simply you will answer कि judicial proceeding का मतलब हुआ कि जहाँ evidence oath पर लिया जा सकता है. Now next question, what do you mean by metropolitan area? If you read section 8 of Criminal Procedure Code, you have the definition of metropolitan area. So metropolitan area is that area which is declared to be a metropolitan area, and only that area can be declared to be metropolitan area, population of which is above 1 million, namely 10 lakhs. Now, define police report. So if you read section 173 subsection 2, you will come to know what is meaning of police report. So police report is a report which is prepared by the police, and the same is forwarded to the magistrate under section 173 subsection 2. Always keep in mind, once charge sheet is filed under section 173 subsection 2, it doesn't mean that police cannot go for further investigation. It doesn't preclude the police, it doesn't stop the police from going for further investigation. Even after submitting charge sheet, if police gets some kind of additional evidence, that investigation can be continued under section 173 subsection 8 of Criminal Procedure Code. So if you get a question, even after filing of charge sheet, we get this question in the PT exam also, and sometimes this question is asked by Honorable Interview Board, whether police can further go for investigation once charge sheet has been filed under section 173 subsection 2. Answer is yes. Even after submission of the charge sheet, further investigation can be done by the police under section 173 subsection 8 of Criminal Procedure Code. This is very, very important. Now, what are the provisions in Criminal Procedure Code relating to arrest of members of armed forces? Now, whenever armed forces are doing some kind of official duties, while performing official duties, if some kind of wrong is done by the armed forces, they can be arrested, but only after the permission of the central government. Clear-cut provision is given in section 45 of CRPC. So if you read section 45 of CRPC, you'll come to know that armed forces, if they are doing their official duties, and if a need arises to arrest them, they can be arrested only with the permission of the central government, otherwise not. Next important question. Once a warrant is issued, now that warrant can be executed at which place? Whether it can be executed only within the jurisdiction of the court which has issued the warrant, whether it can be executed all over the India. The answer is that when once a warrant is issued, it can be executed in any place in India. That is the answer for this question. Now, next question. Whether it is necessary for police officer when he arrests a person without warrant to inform him about the grounds of his arrest and right to bail. Well, when a person is arrested, whether he has committed a bailable offence or non-bailable offence, that's a different issue. If you read Article 22 of the Constitution of India, among us many rights which are available to the accused persons, one of the rights is that he must be informed of the grounds of arrest, and he must be informed whether the offence is bailable or non-bailable. And we also have relevant provisions in section 50 of CRPC, grounds of arrest, where all the grounds which are mentioned, police must inform the person whether the offence is bailable or not. So, whether the offence is bailable or non-bailable, that is immaterial. Police must inform the arrested person that whatever offence he has committed, whether it is bailable or whether it is non-bailable. That is very, very important. Now, next question. What legal action may be taken against person absconding? Well, just now we have discussed there are 4 processes to compel appearance of a person. First is summon, second is warrant, third is proclamation, and the last is attachment of property. So even after issuing of warrant, the person is not being arrested. Then the next stage which can be done is that warrant proclamation can be issued, and even after proclamation the person is not appearing, then lastly order for attachment of property can be done. Now, whether a father is entitled to get maintenance from his unmarried daughter? Yes, father can demand maintenance from unmarried daughter if she is earning, if she is in a position to maintain her father, then that can be demanded. Whether a father can get maintenance from his married daughter? Answer is yes. Now, whether an adopted son can claim maintenance allowance from his father? Answer is yes. So in all these cases, maintenance can be demanded. Whether divorced wife is entitled to get maintenance? Yes, until she gets remarried. Till she gets remarried, she can demand maintenance. Whether a widow mother can get maintenance allowance from her married daughter? Answer is yes. Even a widow mother can demand maintenance from her married daughter. So that provision is there. Whether a wife living in adultery is entitled to get maintenance allowance? Answer is no. Read section 125 of CRPC. It says that if the wife is living in adultery, or if she is living separately without any sufficient cause, or if she is living separately with mutual consent, then on all these grounds maintenance can be refused to the wife. So if the wife is living in adultery, clear-cut provision is there in section 125. Maintenance cannot be granted. Now, whether wife living separately from a husband by mutual consent can claim maintenance allowance from a husband? Answer is no. She cannot claim maintenance allowance from a husband if she is living separately by mutual consent. Now, very interesting question. Many a times the students ask this question, whether a Hindu husband has a right to get maintenance allowance from his wife. Now, under section 125 of CRPC, a Hindu husband doesn't have right to claim maintenance from his wife. But read section 24 of Hindu Marriage Act 1955. In special circumstances, under section 24 Hindu Marriage Act, under special circumstances, husband can be maintained by the wife. So if you read section 24 of Hindu Marriage Act, under special circumstances, husband can be maintained by the wife. Under section 125, this provision is not there, because section 125 clearly speaks of maintenance of wife, parents and children. Now, otherwise, under section 125, a husband is not entitled to get maintenance from the wife. But under special circumstances, he can claim maintenance from the wife under section 24 of Hindu Marriage Act. Now, whether in case of default in payment of amount of maintenance, a warrant of arrest can be issued. Yes, if the concerned person fails to pay the maintenance which has been ordered by the magistrate, a warrant of arrest can be issued against the person who has failed to pay the maintenance. Now, before whom an application for getting maintenance allowance should be filed. Now, किसके सामने हम लोगों को maintenance file करना है, application file करना है to get the maintenance? Well, this can be filed before judicial magistrate first class as it is mandated in Criminal Procedure Code. So, maintenance allowance, it has to be filed before judicial magistrate first class. So, these are some of the questions which actually need to be prepared by you, and these questions are very technical in nature because they are question like whether husband can claim maintenance from wife or not. So this is a question in every batch. Students ask this question because everybody know husband has to maintain the wife. Whether wife is also liable to maintain the husband, this is a very interesting question, and if you read section 125, you won't find answer there. But if you read section 24 of Hindu Marriage Act, very much answer is there. Under special circumstances, this can be done so. So these are some of the questions which must be prepared very thoroughly by you, and in the next lecture we'll try to cover more questions from CRPC so that all the questions which are asked from CRPC we can get acquainted with those questions, and then we can prepare thoroughly as far as CRPC is concerned. Of course, in the coming days, in the more lectures, we'll be also discussing questions from CPC, IPC and things like that. But as far as CRPC is concerned, I'm trying to summarize as many questions as which are asked in the examination. So I hope these questions will be very helpful to you. Please read these questions very carefully. Please maintain lengthy notes on these questions, and if you prepare these questions, because I have put up all these questions have been asked in various competitive examinations, of course judicial examination, and when I take feedback from the students, they told me, so these are the questions which have been asked from CRPC, these are the questions which are asked from CPC and things like that. So I'm basically focusing on those questions which are very important and which are frequently asked in the examination. Thank you so much.